Tonight, we will take an up close look at the WARN Act. The Worker Adjustment and Retraining Notification Act, or WARN Act, is a federal law overseen by the Department of Labor's Employment and Training Administration. It is intended to require advance notice to workers and impacted communities in mass layoff and plant closure scenarios. This is put into law via Title 29 of the United States Code, Section 2101. This can be found at uscode.house.gov. This statute defines the parameters under which the WARN Act applies. Briefly summarized, it applies to employers with more than 100 employees, excluding part-time workers, unless the aggregate work of all employees exceeds 4,000 hours per week. The scenarios in which this act is triggered are plant closures, whether permanent or temporary, or mass layoffs at a single site of employment that result in a 33% reduction in force or 50 or more employees losing their jobs during a rolling 30-day period. The act is also triggered by any mass layoff of 500 employees or more. This also defines employment loss as termination, a temporary layoff exceeding 6 months, or a reduction in working hours of more than 50% per month over a rolling 6-month period. The WARN Act is regulated per 20 CFR Part 639. This can be found at ecfr.gov. This is where the DOL's regulatory involvement comes into play. Here it is specified that layoffs meeting the criteria from the legal requirements must give the impacted workers at least a 60-day notice in a mass layoff or plant closure scenario. In addition, the minimum 60-day notice must be provided to labor unions representing employees, if applicable, and state and local government officials. It is also noted that violations of the WARN Act cannot be legally enforced by the Department of Labor, and any enforcement actions must be implemented through private lawsuits in a federal court. The definition section gives details on terms the law only mentions, such as affected employees, part-time employees, and single site of employment. Further details include timing of notices, who must receive them, what information they must contain, and more. Guides and other resources are available through the DOL. This includes guidebooks for workers and guidebooks for employers. There are various reasons why a company may not want to file a WARN Act notice. These include the operational implications of giving employees a 60-day or greater notice, including productivity, quits, or potential property loss. There's also the potential impact to company valuation or stock price, and early warning signals to competitors. A company may be further encouraged by the fact that it is not actively regulated by the DOL. If the act is violated, it is up to the other party to file a lawsuit. There are a number of law firms that specialize in WARN Act violation representation. As the WARN Act is limited in scope and doesn't cover all layoff scenarios, tracking WARN notices alone only sheds a small amount of light onto the entirety of the job loss picture. WARN and non-WARN layoff aggregators and trackers can provide greater insight, and several will be shown in depth in the next episode. Good night.